pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please, Mr. Gitschlag.
Mayor Milan.
I am here.
Councilmember Anderson.
Here.
Councilmember Sampson.
Here.
Councilmember Shepherd is absent. That is enough for a quorum, Madam Mayor.
Thank you very much. Next thing on our agenda will be public comment. If anyone would like to speak for items on the agenda, they can come forward, give their name and address, and we'll allow you 3 minutes for your concerns.
Susan Moffett at 726 Drion. I wrote up my thoughts so I could be somewhat coherent today. George's had the power going on a year ago to put this ugly chapter behind us, and he chose not to. The community was enraged at the egregious actions by him and past and present council members. Any resolution will be scrutinized by the community, and anything other than a respect for the community's outcry for George's to walk away and this chapter to be put to an end will be a slap in the face to this great community. We hold this council responsible to serve the community first, respect our voice. We have been clear. You represent us.
Thank you. Would anyone else like to speak?
Karen Knutson, 1313 North Bywood. Everything she said, I double. And my neighbors, this is just outrageous to be held hostage as a city by one person who's so selfish. And, it's obvious we don't want him. Like, I don't understand how he can tie us up this much. Hopefully our attorney can tell us. Thank you.
Thank you. As there is no one else available, we will move on to the next item, which our agenda states that we have consideration of going into closed session to discuss the litigation for the George Paul Georges versus Clawson City Council and City of Clawson. We do not have intent to go into closed session. The intent of this meeting was basically to get an update from our attorney, Mr. McGinnis, on the status of this case. I will let him come before us and state where we are, and then we can see if we have any questions or concerns with that. Thank you for being here tonight, Mr. McGinnis.
Absolutely. Thank you, Madam Mayor. So where we stand right now, the case has continued to progress as it normally does in the background. You haven't heard a lot about what's been going on because a lot has not been going on, basically. And so everything's been moving towards continuing on to trial if this case ends up going to trial. We have kind of our ducks in a row as to what we need and the information that we need. I can't get into specifics of that right now. But where we stand right now is we're at a period of time for mediation. So initially in the court scheduling order, the court was going to order case evaluation. And I know I've spoken before about case evaluation. I think I've spoken publicly on it as well. And case evaluation, and I apologize if I sound a little off. I do have pneumonia right now.
Oh, of course you do.
Just to add more fun to everything right now. I'm not contagious, though. I've gone through the course. It's just enough to wear me down a little bit. But in case evaluation, that's where a panel of attorneys would decide on a case, and it's generally limited to monetary relief. As you know, this lawsuit was filed less on the basis of monetary relief, and it was filed more as declaratory action to try to for Mr. Georges seeking to get on counsel. And so while this delay has occurred, and there's been a delay, and the residents can look at it as this has been going on for a long time, as it's been going on for a long time. But one of the things to note is while this has been happening in the background, he has not been on counsel. And so we've been able to there's been no preliminary motions brought or anything brought to try to seek that type of relief at this stage. And really, we're beyond that stage right now. So at the stage right now is the case would normally go to case evaluation. Case evaluation would not produce any type of results that would actually resolve this case. And so because of it, this case was not really appropriate for case evaluation. It would have just been the city spending money to check one box. We had a conference with the court, and the court was going to order the case to facilitation or mediation. And so the court agreed to allow us to essentially waive case evaluation. And and just do a mediation instead, which we're more likely to resolve a matter through a mediation than through a case evaluation, where all the case evaluators can do is say, I award X party X dollars, I award this other party X dollars, and either net them together or do something different with that, which would not have resolved this case because of the equitable nature that was sought. So at this point in time, we're really left with needing to move forward to mediation and picking a date for mediation. And I know I've submitted dates kind of along as to try to see what we can do. We've been unable to come to a consensus on a date. We have another date available. I believe it is coming up next week on the 9th. Is that
That's the date you gave me, yes.
the date I gave you? Yeah, that's a time when the mediator who has experience in dealing with municipal law and public works and has done other things as well. He's mostly been out of Macomb County, so there's a little bit of a removal just from the local county sense. These were all comments that had been brought by this council going back now quite a while when looking for independent people. I tried to take the same approach in coming up to an agreement for a facilitator as well. That is an evening that he still has available to be able to meet in the evening, so to have the least amount of impact. And it is something that we would need council all present, either physically there, or if somebody cannot be there due to an illness like any of these illnesses that are going around, then we need at least them to be there via Zoom so we can get everybody's consensus at the time. The next important date coming up will be on December 13th, and that's a status conference, which this court has held and is referring to as a settlement conference as well. So mark that down, because as we get closer, we'll verify that information with the court. If the court deems it to be a settlement conference as well, then the council would need to be present for it, because they would require everybody with the settlement authority to be present for that meeting. And due to the nature of this type of case, this is not the type of case where I feel that we can easily come up with settlement authority for you to give me in advance. I feel like it's something that would need everybody present to be able to try to resolve. Because again, we're not talking about something as simple as what's a dollar amount on the table for both sides. We're talking about something that's more equitable and something that I think reaches the city a little bit deeper and the individuals involved. And then if that doesn't resolve itself, then the case will be set for trial kind of coming into next year. At the status conference, the judge could do a number of things. The judge could either order us back to facilitation, hopefully not because of the close nature to this. But either way, it'll be set for trial. And then we would move forward towards a verdict at that point. If the case is set for trial at the end of January, realistically, by the time we get all of our trial dates set with witness testimony, we could be looking at March, April, almost even into May before we have a full trial date and an ultimate verdict on the case.
Okay, so to date, last time we met, we requested that you present something to.
That's correct.
The other side. They rejected it,
That's correct.
right? And then we hadn't had any contact with you at all
That's correct.
after that. And we finally connected.
Yes.
And you told me that we were ordered by court into mediation.
That's correct.
So if I go to the website, and I'm not an attorney, I'm just asking for
Sure.
clarification. If I go to the website and look at the paperwork that's in there,
Sure.
it doesn't show any meetings or anything like through the case notes, right? Should there be something there that says you met with the other attorney and this is what you guys came up with, or you met with the court? Because all I see there is a stipulation.
Sure.
And I'm not an attorney, but my understanding of a stipulation is both parties agreed to this thing, and we, as a body, voted specifically not to allow for mediation. We said no mediation on a meeting in August. And then I'm just concerned that it went to this without council approval.
So,
And
yeah,
if it was mandated by the court, where's the information that says it was mandated by the
So,
court?
a couple points. One, I believe this council on more than one occasion has tasked me with the ability to try to manage the case and manage it as a case would progress. And so when it comes to status conferences with the judge or the judge's clerk, they don't update all those notes on the court docket, not unless there was an official settlement conference hit. We knew we had case evaluation coming up, and so I spoke with opposing counsel. We contacted the court because, again, and I had told this, I think, to this panel before, that case evaluation would not be fruitful for this type of case. I mean, you would just be wasting money to waste money. And so we wanted to be able to opt out of case evaluation. The court said we can do that, but we would have to agree to mediation. So, and just from my years of practice, just so you know, my just general course of practice of doing what I've been doing, the courts ultimately always order some type of mediation or facilitation before the case goes to trial.
But you accepted it without seeking without even consulting us. And I didn't know that's what this, I just did investigation, and that's what that happens to be. And I personally have a little issue with that as a resident, to think that, I'm not saying you're doing anything wrong, I just want to know that you're informing us of every single move that's been made. And if you think that case evaluation would not be worth our time or money, I don't understand how mediation could be worth our time or money, given the fact that we've sat in a room with ourselves and not been able to come to a place on numerous times where we're going to agree to concede to move forward. So that's what mediation would be. It would be us having to agree to
Sure.
concede to move forward. So it feels like that's just a lot of nothing. Also, which will cost us time and money.
It'll cost some time and money. There's a couple things in any type of case, and I believe I've said this to this council before, and I've said it publicly. I would never, in my practice, ever refuse to attempt mediation, nor would I ever want to tell a judge that my clients have refused to attempt to resolve a case prior to going to trial. I mean, at the onset, what that tells me is that, and what that would signal to the judge is that we're the unwilling party towards any type of resolution in this matter. And if we want to come across as the unwilling party, we can do so. That's just not a strategy that I have ever found to be effective, and it's not a strategy that I ever try to maintain. And something like mediation, something like general case management, to me falls under the purview of just generally managing a case. I understand clearly you disagree, and I can set these meetings anytime there's any little change or update. There was not an update. I mean, I said about the mediation and I requested some dates.
So the mediation had a date on it from the court of September 12th or 14th or something like that. And I only spoke with you, what days were we at that conference? The 24th, I spoke with you while I was driving to Muskegon, which is why I can remember it. I was in my car for a long period of
Sure.
time. So that's when we spoke. So that's a month before, and it wasn't brought to our attention that we were going to be entering into mediation. And this is a community thing, right? This is like
I understand.
every single part of this should be as open as possible. I understand we cannot discuss strategy here because it's a legal case, but this isn't strategy. This is ensuring that we're acting as this body chooses to act, and that
Sure.
we're acting openly, right? We've had residents come here since this started almost a year ago. What's going on? What's going on? What's going on?
Mm-hmm.
Like, I think people should know what's going on, and I think it should be not a surprise later on, and it shouldn't be almost 6 weeks or a month or 6 weeks before we're notified that there's something going on, and we shouldn't have to go to the website to figure out what's going on. And I feel like I don't want to, I trust your expertise, except this makes me question because it's not been transparent. And,
There's nothing-
and we
there's
did
nothing
not,
hidden.
we specifically said no mediation. So you were part of that. We came back from a meeting, well, actually it was a regular meeting. Councilmember Sampson motioned, he made 4 motions that night. One of them was mediation, one was bringing Mr. Georges back the following week. One was, well, I don't remember the other 2, but I do remember those 2. And we specifically did not agree, hence we did not move forward with any of those things, which is a clear picture that that was not something we were looking forward to. And if you had a direction for us to go, we should have been advised of it, not just, before you signed the document to say you were agreeing to that, it should have been brought to us, should it not?
I think when it comes to general case management, if that's the case and you want every tie my dot and I or do something that's in general case management to come before you, that's fine.
So that's not
I will
dotting an
just,
I.
I will tell you that this is the first time ever in my years of practice where anybody's had an issue with this. So that's okay. I can do so, I can do something a little bit different. Part of the delay was we had to find a mediator. There's no point in me, I'm trying to come up with the information. We're coming up with the information. Then I reached out to request some dates. Yes, you had voted no mediation, but there's been so many contradictory votes going back and forth if we want to look a little early on. But the one thing that was consistently voted upon, and what my understanding was that I was to manage this case and manage this case as the case should be managed. So when I know that there's judges, and I've said this to you again and again and again, that if I believe a judge is going to order something, I'm not going to argue and stand against the judge to do that. You could sit there as a body and vote, we vote no, we're not going to comply with discovery rules. Okay?
Okay, so let's not be ridiculous, right? We're not going to be ridiculous, but it's not ridiculous to expect to be informed about a decision that you made on this board's behalf. And you made that. Now, if you would have come to us September 10th or whenever you knew about it, before you signed the document, and said, this is what's going on. We met, this is the most logical step. We would have had to come up with a consensus on that, but you didn't allow us that opportunity. And this whole process has been convoluted from the beginning because, those of us who really wanted to try and keep it clean and keep it away from it, specific people or specific areas or have someone with certain expertise. Everything has been decided for us, right? You're here because someone decided that for us. And I'm not saying that's a bad thing. I'm just saying every part that has been significant about this whole process has been determined for this body. And that if that's how it's going to be, then we don't ever need to meet. You just tell us what happens at the end, and that's not what we're going for either.
No, that's not what we're going for. And again, when it came to things like mediation, we've sat in there. I brought up the fact that we were going to have mediation in closed session. I brought up, we've had a lot of conversations, and maybe we should make more of them public, and I'm fine with doing that as well so that I don't feel like I'm blindsided coming into something here as well, which is perfectly fine. Again, I'm moving forward in the way that a case typically progresses. If this body wants me to go to the judge and say, Judge, we say no to mediation, I will let the judge know that against my advice, this is how my clients wish to proceed.
Well,
And that's exactly, other than coming here again, just tell you the same thing, which again, I can come here every single city council session. I have no problem doing that and giving an update. And anytime I've been asked to come here, I've come here. And even tonight was a closed session. I found out that somebody was going to be ill. And I said, well, then let's just continue it as an open session. It's here.
my intent actually was for an open session, so I may have mistakenly requested it closed, but I knew we weren't discussing anything that couldn't be shared with the public. And this is not to share with the public that, oh my gosh, people are doing what they want again. That's not it. This affects the public, right? This is
100%
does the
it
public
does.
carry this whole thing? And all we've asked for throughout this is for it to be done the right way, right? Because, and a right way that in process, not just the right way that someone thinks it's the right way. It has to be done correct in process. And personally, I don't understand how, if we say no mediation, you feel comfortable signing something that says mediation without talking to us first. That's all it would have required, was a conversation. And this was not to beat you up. This is for understanding. I could have been 100% wrong on all of this. And you could have said to me, you're 100% wrong. And I'd be like, okay, wrong again. But
Well, I'm not going to say that.
we're working on behalf of our residents. And I personally take that, I want this done well. And I want it done fairly, and I don't want people making decisions on behalf of the board. Now, if we can't make a decision, which clearly, that's why we're sitting here today, because we've been yet to be able to make a decision.
That's correct.
That's one thing, but we deserve to be presented with the information. I think our last meeting was sometime in August, and I didn't hear from you until October 24th or whatever it was.
I thought I had a conversation in between then.
Maybe
dealing
early,
with
but it
the
certainly
fact
wasn't
that we
about any of
presented.
this, right?
No, but I mean, we've had so many conversations, so maybe that's a mistake on my end, is that we've had so many conversations.
But some conversations are important,
That-
and giving someone the right to sign their name on our behalf, that's not, like, that's got to be an absolute. Any comments?
Yeah, Madam Mayor, if I may. You'd informed us on several occasions that before we ever went before a judge, there would be some mandatory mediation.
That's correct.
Okay. Is what we're undergoing now part of this mandatory mediation?
That's correct.
Okay. I think the mayor's concerned, because you got online, looked at the paperwork, and it didn't seem to imply that.
Right, we would have gone to the status conference, which would have been a mandatory settlement conference as well, and that's part of what I was explaining. And then generally what happens is when it doesn't settle at that time, 99.9% of the time, probably 100% of the time in every case I've had, the court then orders everybody to mediation. So an order would come out of that status conference saying, here it is, now go to mediation. And then the reality of that situation is we're now in December, Christmas time. By the time we find a mediator that's available, we're probably talking adjourning the trial date out another 30 days or 60 days, maybe even further, to try to get to that point. I know it's been a desire to try to move this along while also trying to do it in a smart way for very strategic reasons. So this would be that mediation that would hopefully get us out of you guys having to appear for the December settlement conference as well, because we'd have already checked this box before moving to the next stage.
So what's the
But
difference?
again, when I look at mediation, am I still hopeful this case can resolve? Of course, I'm still hopeful this case can resolve. I don't know if it's going to, but I would be a bad attorney if I sat here and said, this case cannot resolve, and let's just keep plugging forward with a certain level of, beating up the file per se.
So what's the difference between mediation and a settlement conference?
Settlement conference is basically, we'll all be jammed in the courtroom with the judge. And they'll put us in some breakout rooms, they'll do a few things, and we'll be there for sure, probably all day, if not multiple days, for people to kind of get to us. Mediation is more hands-on, one-on-one, so that the case can try to actually get to the issue to try to resolve the issue. The judge is limited on what he can actually do in his involvement in trying to settle a case, because he's the ultimate trier of fact in the case.
So it's almost the same process, just different players, mediation,
it's
you're gonna pick
completely-
someone, and I'm not comfortable with anyone from Macomb County, I'm just gonna say that right now. So could you please find us someone outside of Macomb County and outside of Oakland County?
I mean, at this point, I guess maybe this is my confusion at this end right now. I mean, are we saying, because again, clearly I was confused, I wouldn't have signed a document unless I thought I had the authority to do so. But since it's clear that I didn't, and I signed a document that you're purporting I did not have the authority to sign, then I'm going to have to go back to the court and disclose that to the court.
Okay, but I'm not purporting anything. We sat in this very room and we made a motion, someone made a motion about entering into mediation, and we did not come to consensus, hence there's no going into mediation. The feeling was that wasn't a strong point. Now, had you come to us and said, this process through the court, if you could show us something that the court ordered a mediation or something like that, then that would be different. That would be a formalized process instead of, let's just do this and see if we can move this along that way. I'm sure you want this to be completed as badly as we do.
Yeah, I mean, I've been trying to do this as efficiently as possible. I've been trying to do this with as much care and dedication and consideration of the city as possible. Every step I take, I'm taking because I believe it's moving the city in the proper direction on our case and moving it in a way that's to benefit our case. If council disagrees with me on that, then that's your prerogative to disagree with me on that. It's your prerogative to have me here at all. You've made it a point yet again to point out that you did not pick me.
Well, that's just a given, right?
I
I'm just saying
understand that.
this whole
I
process was
understand that,
not
but-
in our hands, right? And it has nothing to do with you. I didn't know you then. I don't know much of you now. You seem like a really great guy. I just want to know that whomever's serving us is serving us. That's all. That's all I'm asking for. And I don't think that's a lot. Like,
No,
you represent
and-
us. And if no one thinks it's problematic for this body to say no mediation, and then all of a sudden we see mediation, but then the document is not a court-ordered mediation, it is a stipulation, which means you agreed and they agreed, but nowhere did we agree. That seems like someone else is deciding for us yet again. And again, I'm not an attorney. I don't do this every day. If I'm
understand.
missing something, tell me what I'm missing, because I'm not accusing you of anything.
Well, I've
I
tried-
just want to be able to understand it. And I feel like better communication sometime between September 12th, when it was filed with the court, or whatever date around September 12th, it was filed with the court, and October, let's say 24th, we should have been informed about that.
The only thing I can say is, he's in a tough spot, because sometimes judges don't really care how we vote. They're gonna tell us, you're going to mediation.
That's
anyway."
fine. Inform us of that.
Yeah,
Don't make that a surprise. Don't let us pick up the papers and figure it out on our own. And it's done. We have to move forward, but
It's not done. It's something very simple. I'm going to go back to the judge, let him know I did not have authority to sign that document, ask the document to be rescinded, and then from that stage forward, we can decide what we want to do forward. I thought I had the authority. Clearly, I did not have the authority. So I will let the court know that I did not have the authority to bind us in any type of mediation. He can go ahead and schedule case evaluation, so that'll be back on.
Well, will he see
Yeah.
us as bargaining in bad faith?
What's that?
Will he see us as bargaining in bad faith?
He's not going to understand why there's an issue with mediation.
Yeah.
But that apparently would have came no matter what. So I would rather it be then coming from me, and then at that point, we can move forward. But
Well, I think we all understood clearly that at some point we'd have mandatory mediation.
that's not true. He never said, there's no reason that we had to have mandatory mediation.
I've said that
No, you
again
said
and
it
again, multiple
that
times.
before we ever see the judge, there will most certainly be mandatory mediation.
Certainly, most certainly. Does that happen with
Oh,
every
yeah,
case?
but-
Is it most certainly
Well, I'm
every
yet to have
case?
it happen. I'm yet to have it not happen on a case of mine. And so, are there cases where it probably doesn't happen? Sure. There's cases where a lot of things happen or don't happen. But if I'm going to go off of my, 14 years of experience, I'm going to go off of what I've seen thousands of times.
Yeah.
And in those thousands of times, I've seen mandatory mediation at some point or facilitation. And I've also never seen a party refuse to do mediation or facilitation out of that process.
Was that when they had an option to determine whether it would take place or not? Or was that just because you made the call for them?
Almost all the time, parties, we know it's coming. When we know it's coming, as general practice as an attorney, we try to move the case forward. One of the ways to move it forward is to get to a point of either mediation or facilitation, knowing that the judge is going to order it anyways. It's the same thing with whatever else is part of the process.
So I guess we're concerned that we weren't in a hurry to get into mediation.
Sure,
That was made clear by the council.
sure.
I think you also made it clear that before we would see the judge, there would probably be mandatory mediation. Okay. Now you're saying you managed to skip a step, which you thought was of no value, which was, I'm sorry, I forgot.
Case
the term.
evaluation.
Thank you, case
Yes,
evaluation.
case evaluation.
Please bear with me, I'm not an
No, that's
attorney,
okay.
but that's so case evaluation would be part of your normal process, but you basically found a way to short circuit out of it.
Based on a change in the Michigan court rules that happened recently,
Okay.
it allowed for us to be able to opt out of it by putting in place mediation instead of case evaluation. So,
So in other words, you were able to leapfrog the process legally, and then basically go to what you're saying essentially would have been mandatory mediation, but instead of waiting for a judge to put out a command,
that's correct.
you simply were being proactive perhaps and just going ahead and advancing the paperwork in anticipation of what would eventually be an order anyway.
That's correct. But it was not so much necessarily just speed up the case. It was also to make sure that we're limiting the time and the scope of what discovery might happen as well. And so that's why it all ties to kind of where it is. Otherwise, if I would have just sat back and did nothing at all, we would have had to fire out, or they would have certainly then done significant discovery, including taking everybody's depositions, which
So
we've
how
discussed.
does this affect discovery at this point?
By putting the mediation, according to this order that we entered, discovery, their opportunity to take discovery would end as of the mediation date. So if they don't have it, if they haven't noticed it up by then, which, if they're watching now, I'm sure they're going to.
Okay. So discovery is a process, that much I know, that takes a certain amount of time and money. So how long would it have been? So at this point, going to mediation, takes us out of discovery at this point.
That's correct.
What would be, if we went to discovery, what would be the anticipated time and money involved?
Time and money on a case like this, if assuming they do everybody's deposition involved, because that's generally where they would go. They would pull additional records. I would guess probably about $20,000.
Okay, and how much time?
That's factored into. I'm just kind of estimating.
I mean, just calendar time. Meaning.
Oh, it would have to happen in a truncated fashion, so it would all be done before December 30th
Okay.
calendar time.
End
so,
of the year?
Yeah, well, by December, it's not December, sorry, January 30th. I
January,
misspoke.
okay.
January 30th.
Okay. So it sounds like, I guess I share the concerns of the mayor in that a lot's been going on, and it all seems very appropriate in terms of how you do your job. We, not being attorneys, have kind of been in the dark.
Sure.
I'll be honest with you, every now and I talk about what's going on with the George's case. And it seems like there was a long period of time where we heard nothing. You were working, doing things, as far as you're concerned, to the best of your ability and the clear conscience.
Correct.
I think we're just concerned that all of a sudden, here's mediation, and we never really talked about it. I guess
and
that's
I
our
get-
concern.
and-
It's almost like because we're not attorneys, we don't know the process. So it's almost like, since we're not as well informed and educated in these things as you, it would be good to kept maybe a little better informed with every call it baby step you take.
Sure. I understand that, and that's something going forward. Again, it's the mistake on my end is I thought we had discussed things like mediation and the case progress somewhat ad nauseum.
Well,
You
you
know,
well,
and-
my
but that's-
impression of what you discussed were all of the options, all of the possibilities, but you still need a stamp of approval for marching orders, right? Like, you
I
gave-
believe I was given a stamp of approval when it was voted upon for me to manage this case and carry the case out as I saw fit. So I believe I was operating under a certain stamp of approval. And again, if that's wrong, I'm telling you where I'm coming from. I'm telling you, I'm not coming from a place of thinking I was circumventing any process. I did not think I was circumventing this body at all. I've made myself available anytime to this body, except for the one time, I think, when I had COVID. And I'm sure that this body appreciated that I did not come in, with that per se. But it's just, other than that, I've done, I think, as much as I possibly can. If this body wants more on the meetings, then I have no problem setting this and coming to every single council meeting and giving an update. If that's what this body so wishes, and I've said that to this body on more than one occasion in the past, that I'd have no problem coming and giving whatever update. I mean, at the end of the day, you guys have hired me and have retained me, whether you initially chose to or not. I'm here, and you're paying for me to be here, so I have no problem coming as often as possible and spending as much time as possible. And so, but every step that I've taken has been done in a way that I believe has moved this process along as most favorably to this city and this community as possible. And I think there were a number of steps that could have been taken early on that might have changed that, but
We're getting close to the end of the year, where things will start changing fast. Let's ask them to come to every meeting for,
Why? No, I'm not at all stating that you've not communicated with the public. What I'm stating is you didn't communicate with council and you made an act. Not only that, but there was a big gap of time before it came out. You didn't bring it to us. We found it. And that's not, I don't need you to sit here every week. I mean, you're welcome. This is your community. Come join us. It's sometimes fun. If you want to come. But I'm not saying you need to sit here to give us we can read the court records, which is how we got here today. We read the court records. We're just asking that if you're going to act on behalf of this body, act with information from the body. Our last conversation was you were taking documents, you took them, they were rejected. That was our last conversation. Nowhere from that conversation on was there a conversation that said probably going to go into mediation. That didn't happen.
again, I mean, all I can say is I've brought up mediation, I don't know how many times, and the fact that it was going to be a necessary part of this process. the, if you feel I acted without the authority of this council, again, that's, I take that very seriously. I will notify the court, and we can decide how we wish to proceed going further, whether you wish to proceed to even have me continue the case going further or not. I'm fine with that review. I'm not that proud of a person. So it's more just, I want to make sure everything I've done has been for the best interest of this city. I've done it that way. I'd make it a point to actually try to get to know people in this city. Even though I know a lot of people say I don't really know anybody or I don't have those connections. I don't know what connections I have, but I try to get to know people and get out to things. It's like, so I do it for the city. But if I'm being challenged and told that I signed something or I exercised authority that was not within my purview and I was told to manage the case, then I take that very seriously. So I will definitely go back to the court on that and let them know that I did not have authority to enter into that stipulated order. And I think at this stage, it probably would be best to look for alternative counsel then.
So
Because-
explain to me, if that's your mode, that that by the fact that we engaged you, that you have authority to act on our behalf, why did we ever meet? Why did we have conversations and then come here? And then my understanding is if you act on our behalf, we have to,
Sure, I cannot.
Order
I
you to
can't
act
go
on
into
our
the-
behalf.
I can't go into the details of a settlement discussion or negotiation, and so
not
you're
asking you to. That's
You're
not
asking me
what-
why we met. So I'm explaining
No,
why
that's,
we met.
what I'm saying is, if you don't need us to direct you, then we would never need to meet, right?
No, there's two separate things. There's the case procedure. There's case procedure, and then there's the actual, what we'll call them, certain merits of the case, or the stuff that ties to the case. Whether or not I decide to have a deposition on a Tuesday or schedule one out for a Thursday is something that I do. Whether or not I decide to limit discovery or limit the scope of discovery to the other side is something part of case management. Whether or not I think case evaluation is good for this case or not for this case is part of case management. And I think any attorney you ask would agree to the same thing. Now, when it comes down to offering a settlement or making settlement negotiations, or when it comes down to what are certain contents of things, I can't do that without you. So I come to you for those specific reasons, and that's why we've had so many of these meetings. And I have not taken settlement offers without the approval of this council. I have not addressed them that way. That I don't have the authority. I don't have the authority to dismiss this case. I can't anyways, because we're the defendant in the case, so I don't have that authority no matter what. But if we weren't, I don't have the authority to do that. I don't have the authority to accept a settlement unless you guys first gave me your authority, which is why earlier I said, if this was a case over just dollars and there was a settlement conference, that's different. I could get you guys to approve an amount up to a certain amount of dollars, and then I can go and handle it. But that's not this case. I know for a fact, after all of our meetings, that there will be no general consensus amongst this body to be able to just come up with one clear thing to give me a direction. And so we've had to have those meetings when it comes to something to where there needs to be a direction. But when it comes to managing a case, when it comes to what questions, if it's a bench trial, what motions in limine I might file, what I might not file, all of that falls under case management. It's why you have an attorney, and it's why the attorney does that and manages those things. When it comes to what I'm actually putting in stuff and affidavits and facts and discovery and disclosures, I need to know from you guys. But ultimately, I think almost every one of our meetings have been trying to come up with some type of resolution. And that's why we've had closed sessions. Otherwise, more of them could be open sessions just like this.
I understand all of that. I just didn't understand why, if we stated that we didn't want mediation, you would enter into mediation without advising us in advance. That was my question.
I think there's a lot of conflicting orders at that time, and I think saying we're not going to do mediation generally is no different than saying we're not going to do discovery. It's going against a normal part of the court process. Now, we've had conversations since then in closed sessions. I've brought up mediation. I mean, I bring it up every time we talk. I don't think, every time we talk, I'm bringing up we need to get into something for this. If we don't want to, then we can show up on the day of mediation, say we're here, but we don't have any intent to participate fruitfully. At least we've checked a box. Or we can say this is our only offer and that's all we're going to do. and we're doing nothing else, and we've checked a box and we proceed towards trial. And everything goes that way. But I feel like the steps I took these steps feeling that they were within my purview. If they were not, then again, I welcome the council to direct me then, because the last thing I want to do is go on and continue to do anything that's against this city's direction. Does no good for me. And it really doesn't, and I take this very seriously.
Well, I think here's 3 facts that I think are pretty clear. One, that we did make it clear that we weren't interested in mediation. That was clear. Well, it was also clear that you communicated to us that if you want, before we see the judge, there would be some kind of mandatory mediation. So I don't think, although we have the authority to direct you, we probably don't have the authority to thumb our nose at the judge. Okay? So you have to work in a very discreet manner. I think the concern is that we weren't in a hurry to mediate. So we really weren't looking for you to go into mediation agreement without at least some information or communication or approval. But I understand not being attorneys, and I know the court system, the legal system has its own processes. And as an attorney, you know those processes and you work them all the time. People like us who are essentially amateurs, we don't always understand what's going on or the pace in which it's going on and what the normal process of things is. So I think I'm trying to interpret this as even hand as possible. You essentially felt you were doing your job
Correct.
because you believed the first step, I can't keep it. You wanted to skip over the first step, which was
Case evaluation.
Case evaluation, thank you. I'm going to write that down. And then also, as a result, you were then hoping to skip over discovery,
That's
which
correct.
carries with it cost.
Correct, significant costs. But
Okay.
again, like I said, I imagine we're going to be moving forward with that
All right. So
after this.
And by going into mediation, I'm assuming you, again, if I say anything incorrect, feel free to correct me. In essence, you're proactively taking a step that would eventually be forced on us anyway. So it's better to be positive and proactive before the courts instead of holding back and possibly stonewalling the court.
That's correct.
Is that a correct interpretation?
That is a correct
All right.
interpretation.
So, I mean, I understand. I think just the mayor and I, and maybe Councilman Shepherd, is just a little, Sampson. And Councilman Sampson, and maybe Councilman Shepherd too. We're just concerned that there was this period of silence where you're doing your job as you feel is best. But we as the amateurs on the outside are kind of in the dark. And then what's happening, all of a sudden, we've got a mediation agreement that we weren't aware was going to happen. So I think that's really what's kind of concerned us here this day. So I guess I view the whole thing as just a breakdown in communication. That's how I view this at this point. So,
Well, do we want him to write the judge and tell him that he did it without authority, or want to forego that part?
I'm not a real big fan of that. I'm not a fan of doing that or changing counsel at this point. Honestly, that's.
Do we need a motion? Motion to allow Mr. McGinnis to continue.
So if I may,
Oh, he's there.
so obviously I do not have a vote this evening. And apologies for COVID intervening this evening. But I would like to try and make sure that we understand that we're moving as quickly as possible to resolve this. Every day this goes by, it's more expensive than it should be. Obviously, we had a situation where things changed when they came and wanted to settle. We tried to go down that road, and that obviously did not work, surprisingly. And now this is where we are. I know initially we were talking about not going into mediation, but that was prior to their involvement in trying to settle. I think that changed the game. So I'd like to try and, again, move forward with this as quickly as possible so that we don't have to continue in wasting any more money than we need to. But again, I don't have a vote in this tonight.
I make a motion that we allow Mr. McGinnis to continue in the direction he's been forging so far.
I'll second.
I'd like to amend that so that in anything that is signed or changes the direction of what we're doing, that we're apprised of it prior to that happening. I'm not asking to micromanage you, but this was not a little thing. This was not a little thing.
I'll add that to my motion.
Please do.
It's okay with both of motion, okay, okay. We have a motion and a second.
Oh, he gave a second.
I'll second it.
Any further discussion? Roll call vote?
Yep.
Okay, just waiting for you to tell me. Councilmember Anderson,
Yes.
Mayor Milan,
Yes.
Councilmember Sampson.
Yes.
And the only thing I would just kind of ask going forward then, since things are going to move fast, if I'm going to need council's approval on any signature that I put forward going forward, just please make yourself available for special sessions within 24 hours notice as much as possible. Because
It's the least we can do.
I can't ask to delay the court system or delay the process on other things that are going to be happening from now until the end. And so,
Does
but
it
I
ever
will,
happen that you have to have the answer right now?
what's that?
Do you ever need the answer for the judge right now?
Sometimes when I'm on the phone with the judge and we're having a conference and they say, we'll waive case evaluation, but you have to agree to mediation right now. Sometimes things happen.
Yeah,
But going forward, I can instruct the judge, again, if that were to happen, I don't have any authority on behalf of my clients. And I will
We're
move
not-
forward,
Yeah.
I will move forward and get the signatures that I need to get. I mean, it's, at the end of the day, it's kind of where anything that I need to sign, I will make sure that I bring it before this council. And so that's all I ask, is that just to be available, so that this way, if I do need to come back quickly, I'm able to do so.
I know the legal process generates many documents. How many documents and how many signatures are we talking about?
Not talking about a lot. I'm just trying to caveat this now, because again, I don't want to have a breakdown in communication again. I don't want there to be anything, if I'm put on the spot by the court, I want to be able to know my direction is, I'm not signing anything unless I'm coming back here first. And that's really all it is. And maybe that sounds trivial, I mean, to you, but it's not. This is important to me. A breakdown in communication is important to me. That has a very distinct meaning in my field
Do you,
and in what I do. And so I take everything today very seriously because of that.
do you ever get in a position where you got to give an answer on an hour? Could you call the mayor? And then she could call us, or go ahead and make the decision herself?
I mean, if we're talking about a vote from council, it's got to be done a proper way, right?
And that's
I mean,
not
I'm
logistically possible.
I'm not going to circumvent one proper procedure that's being told improper for another improper procedure.
I think the request, I guess if it needs a clarification, we'll make the clarification that it's not to say that you may not enter into normal proceedings or like rudimentary functions, but something such as entering into mediation was not a small rudimentary function. That was significant to those of us who said we weren't for that. Had you come before us and said, look, this is the next process, I did say this could happen, but you also said many things could happen. They've yet to happen. If something's going to happen that changes the course of where we are, we need to know about it. That's all. That's all I'm saying. I think that's what you do. It's communication. And it's responsibility. And we should know what's happening, and you should feel good about what you're doing in the process. You shouldn't have to feel like someone's going to surprise you later on because you did something that
Sure.
they can surprise you for.
I mean, I feel good about what I've done in the process so far. So, I mean, I understand your position. I understand what you define as different levels. That's why I'm asking for clarification, because my background's going to tell me something is of a different level of importance than something else is. That's what I do. But it's not my job to argue with my client over that. If my client wants more information, I give my client more information. I mean, that's really what it comes down to. And so, I feel bad that there was a breakdown in communication, because I don't ever want that to happen. But I do feel like I've been doing and handling this case to the best of my abilities. I don't believe that I've done anything against that.
If I if I can get some clarification on the motion, I don't believe it requires you to ask us for permission for every signature. I think it's asking that we be kept informed every step of the way. Maybe even before you sign a document,
Sure.
shoot us an email. And
I
we
can
can
do
look
that.
and say, whoa, that's a big deal, we should have a meeting, or no big deal, just proceed. I mean, you are a counselor, you're a representative,
That's
you're not
correct.
our puppet. So
Yeah.
we have to give you some discretion to make judgments, but I think if you just keep us better informed each step of the way. Again, we're amateurs. To you, these are just incremental steps in a job that you've been doing for years.
Sure.
To us, every step is like a new adventure, right?
Sure.
So I think this is what I would encourage.
Yep, I understand.
Well, while we're still talking, you'd mentioned a mediator from Macomb County. Again, I feel like there's a lot of connections in Macomb County. I would like you to try and bypass, if that's at all possible, and go somewhere a little bit with someone that might not have great connections to people in our community.
So no connections to people in Oakland County, so, and we don't want Macomb County. I'm going off of a lot of the comments that came up from before, but I will definitely try to find a different mediator as well.
How much time will that take? I mean, what does that entail, having to find a new mediator at this point?
I mean, at this point, it's just going back to the drawing board of who mediators are. I suggested a handful of people. They suggested a handful of people. This person's name came up on both of our lists. And that's generally how mediators are selected. And we described, I went through that with you guys before when I said, in any of this process, that's usually something that the attorneys will select are the mediators. And it's just who we think can best settle the case. And a lot of that's personality driven too, and personal experience driven. We found somebody that I think is in the best position to try to resolve our case. But if we want to throw out the county, then we can throw out the county. I can go somewhere else. I'll come up with another list of names. They'll come up with names, and if we can't agree on names, then the judge will appoint somebody. And whomever the judge appoints is just going to be whoever's just kind of next on this list.
Okay. Are you saying you had a list of names that were acceptable to you?
Mm-hmm.
They had a list of names, acceptable, and there was actually an intersecting name?
Yeah.
Okay.
And that's how 90% of all mediations get picked.
I think we need to give them some input on that. I mean, if we're going to tell them that Macomb County is too close, we need to give them a map,
Yeah.
what's acceptable, what's not. I mean,
The reasoning behind that is we have people who do a lot of litigation in Macomb and a lot of litigation in Oakland, and it just seems like it would be nice if it was someone that might not have a connection with any of the parties involved in this, just to keep it a little cleaner. I know they're supposed to act within, ethics standards and all,
Sure.
and they're probably all fine, but maybe they're not, I don't know.
So are we looking for somebody from a county that does not border our county? So are we going 2 counties removed? I mean, just so you know, at that point, I'm flipping open a phone book to pick a name.
yeah.
I mean, I know a lot of attorneys in the Tri-County area. I know most of the attorneys I know are probably Macomb and Oakland. That's where I've done most of my practice. So if I go outside of that, it's really just,
So at that point, in other words, the attorney, the mediators that you would want are pretty much in Oakland, Macomb,
some in
maybe
Wayne.
Wayne.
Yeah.
So that's your area. So if we go out beyond that area, which I understand the mayor's desire to get somebody that's kind of outside, or really to be, the real goal here is objectivity.
Yeah,
Not necessarily
mediators have a desire to settle a case, because if a mediator gets a reputation that he can't settle cases, then nobody goes to that mediator anymore. So there's I guess that's a little bit subjective on their end, because they want to get a case settled, but it can't be settled unless everybody agrees. And so we look for people that are generally successful at resolving issues, because otherwise, what's the point? But
Okay,
So,
I-
not accepting this guy's gonna put us back another month or 2.
yeah.
we got December 13th. I mean, that's our next actual important date. So All it does is it'll just, whatever normal delay, it allows the discovery window to stay open.
I guess.
Discovery window can stay open until that time, so.
I mean, at this point, I guess the key is you produce a list, they produce a list, there was a common intersection
Yeah.
point, which tells me that that person's agreeable to you and them.
That's correct.
And I understand the desire to make the person as distant, but again, let's face it, the law, like any industry, the law industry is it's a
Close-knit.
family of people
It's-
that know each other, right? Because you've been
Yes.
working amongst yourselves for years.
That's correct.
So you'd rather opt, in other words, despite the fact that your list contained people that were pretty much just in the tri-county area, by and large,
Yes, they
you
all
feel
were.
comfortable with everyone in your list. And at least you had one common name. I'm just curious, are there any other common names between your two lists?
No. No, there weren't any other common names. We probably could have thrown them out again and gotten another common name, but, at some point, there's certain mediators out there that are even better, but they're booked out 6 months. And the judge would not allow that. The judge wouldn't allow to sit, for that.
Do we need a motion to go with the arbitrator you just got?
Yeah,
I'll make a motion, we go with the arbitrator who's already picked.
Mediator.
Mediator.
do we even, honestly, do we need to do a motion for this? I mean,
Yeah.
he,
This is
It's
just
his
splitting,
responsibility.
This gives him,
yeah.
well, but this is, again, we're splitting the lines of how much is case management and how much is not. And again, it's up to
Right.
you guys to define that, if you want to pull out of the normal.
How about this, just to resolve it, we'll do that. So Lou, go ahead and repeat your motion.
make a motion to accept the mediator,
Mediator.
that Mr. McGinnis picked.
Was there a name there?
Erica Shockey.
Where's he from?
Eric who?
Ashaki.
So a motion by Councilmember Sampson.
Pardon?
So you made the motion,
Yes.
just repeating that.
I'll second it.
So we have a motion to second, so if I may. So whatever comes out of this mediation, we don't need to accept if we don't like it. Is that correct?
That is correct.
Okay. Good, that's all.
Roll call, please.
Mayor Milan,
No.
Councilmember Sampson,
Yes.
Councilmember Anderson.
Yes.
Passes.
Thank you.
Okay, do you have anything for us?
No, I do not at this time. I think I've probably talked more than I needed to.
So we still need to come up with a date to enter into this mediation. The date that you provided were not available, so we're gonna have to go into the following week.
Okay. Let me see what dates I got.
Was it the 9th was his proposal? Or?
Yeah, I had been sending all the dates directly to the mayor, but I'll send it to the entire body. So I will
Please
get the
do.
dates and send it to
Bumped
the.
them all around.
Was the 9th the only one that, did everybody else make the 9th?
I was
I
okay
can't
with
do the 9th either, I have a
Oh.
job fair that day.
All right.
Late
Okay.
day.
Too bad, that was a good day for me, but okay.
I'll see what other days he has that are in the evening. Those are always more limited appointments.
Well,
they're
I
in
mean,
the
I'm willing
evening.
to do an afternoon, but as long as it's kind of later in the afternoon, so it's
Yeah.
not an entire day.
and it
No,
needs some,
they're half-day sessions, and so either if we want to do later in the afternoon, we can do later in the afternoon, but he'll stop at a certain time, and we'll be paying from 1 till, they'll start
So you
the
either get
clock.
like 1 to 5 or 6 to 9 or something like that?
Yeah, they do sessions that way, and you can book a full day if you want, or you can book a day and a half, but they do them by
Blocks.
session
Blocks of
blocks
time, yeah.
of time, so. There's no point in coming in at 4 o'clock for an hour. I mean, unless we can do the full evening too.
okay.
Yeah, we just wouldn't want to pay for both sessions, so
No.
I might as well just wait to do the later session. Okay, then thank you for this. If no one else has anything else,
Motion to adjourn.
motion to adjourn. Support? Roll call, please.
I'll support. Oh, you support, I'm sorry.
Sampson,
Yep.
Anderson,
Yes.
Milan.
Yes.
We are adjourned. Thank you.
Thank you, everyone. Thank you for the update.
Thank you.
Appreciate your help.